The following lecture is copyrighted by Rick Ramos or Contra Costa College. The copies of this lecture or audio material may not be distributed without the express written permission of Rick Ramos or Contra Costa College. Hi, this is Professor Rick Ramos, and this is Administrative Justice 122, which is our criminal procedures course. We're going to be moving into the area known in the Police Academy as Learning Domain 15, which deals with laws of arrest. Now, what's interesting is that there's a high number of police cadets that flunk this area, and so hopefully by giving you about twice as much time in this area as is allotted in the academy and going more slowly and methodically and giving more information to work with, we're going to be able to get you past this material. The first thing that we're going to be dealing with is kind of an overview of what it is we'll be talking about. And when you're talking about basic laws of arrest, there are three different categories we're looking at. We're looking at consensual encounters and contacts, and then we're also looking at making an arrest of someone. Well, what we want to start with is that we need to review a little bit on the Constitution and the Bill of Rights, because when you stop somebody or you arrest somebody, the contention is it's a seizure under the Fourth Amendment. So let's go back a little bit and review some of that material. By the way, you can download the PDF of the PowerPoint lecture that's associated with this and use it as a notebook. And there's going to be far more information on this audio lecture than you're going to get in PowerPoint. So make sure that you take some notes along with looking at the actual slides. I've provided a couple of research areas for you, www.findlaw.com, and also there are a number of other areas, U.S. Code of Federal Regulations and U.S. State Code, for convenience for you if you want to look up any of this material. First Amendment deals with the freedom of speech, press, and assembly. The Fourth Amendment deals with the people to be free from unreasonable acts by the police, and it deals with search and seizure. Now, the Fourth Amendment says that we're supposed to, we can't be subject to unreasonable searches. It doesn't say you can't be searched. It says it can't be unreasonable. And there's a requirement for a warrant or based upon probable cause. And so that's really what this lecture is going to be about. The other thing that we're going to deal with in the totality of this lecture, Lecture 3, is when you are required to administer the Miranda Warning to someone. And the Miranda Warning is based upon Fifth and Sixth Amendment rights. So Fifth Amendment, of course, is the right of a person not to be compelled to testify against themselves. And Sixth Amendment gives you the right to speedy trial and also judicial review while in custody and the right to have an attorney to provide legal representation for you. We also have the 14th Amendment, which basically says that states can't enforce any laws or write any laws that are in violation of the Bill of Rights, that no one can be deprived of any life, liberty, or property without due process of law. Now, when we talk about due process, that means there's a legal process we have to go through. Now, in Lecture 4, 5, and 6, we'll be dealing with that process. What this is really talking about is what we call the accusatory process. It's the beginning of it, how to make an arrest and then take the person through the system to have the system determine whether they have to even stand trial. I'm going to give you my little talk about ethics at this point. Many times in an arrest situation, the only person that's there is the officer and the suspect. And it's paramount that the officer play by the rules. The only difference between the crook and the officer is the fact the officer abides by the Constitution and follows the law. The crook doesn't do that. The bad guy doesn't do that. There's many times you'll be tempted to make arrests or collect evidence that you know is illegally collected because you know that the person's guilty. But the thing you have to realize is in our system of government, we have to follow the rules because ultimately that evidence will be excluded. Now, you could lie. You could write a false police report. But if you get caught doing that, it's an embarrassment to yourself. It's an embarrassment to the department, and you're going to lose your job. So it really isn't worth it. Most police departments have rules that will say that untruthfulness is a fireable offense. There are also federal laws that prohibit you from violating people's rights either by lying or conspiring. It doesn't matter. Let's go through those right now. The first is Title 18, Section 241 of the U.S. Code. And what this says is it basically says that it is illegal to conspire to violate somebody's rights. The actual law says, as it's defined, conspiracy against the rights of citizens. If two or more persons conspire to injure, oppress, threaten, or intimidate an inhabitant in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more people go in disguise on the highway or on the premises of another in intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured. And the punishment is that it's not more than $5,000 imprisonment of not more than 10 years or both. What the heck does that mean? Well, let's take this apart. You're with your partner and you make a car stop. The suspects look kinky to you. You think something's wrong. So you order them out of the car and you have your partner distract them while you search the front seat. Well, you've committed an illegal Fourth Amendment violation by committing an illegal search. Your partner helped you by distracting the suspects at that time, and so therefore that would be a good example. Other examples would be that you and another person conspired to write a false police report which indicates that someone's guilty of a crime when in fact they didn't. Or you ignore certain evidence that you know is applicable to the case. Anything where two or more people have a plan to violate somebody's rights, that would be a violation under this area. Also, this is used in civil rights violations against extremist groups like the KKK or other groups that might terrorize certain groups that they target. And here it says if two or more persons go in disguise on the highway. So if you can remember the KKK wear their hoods and run around and do things to folks, or on the premises of another. So if they come on your property and burn a cross or what have you, that would equate to a violation under this section. Again, under 241, the crime is always a felony. The section doesn't require contact with the victim because the statute prohibits a conspiracy to violate the rights of someone. So it could be, conspiracy basically says that two or more people have a criminal agreement and they have a plan, and then they commit a overt act toward the completion of that plan. So if you can remember the movie Mississippi Burning, where they had these corrupt sheriff's department would arrest blacks, mostly black males, and then they would release them like really early in the morning, and the KKK would hunt them down and either hang them or injure them. If someone just got note of that situation coming down, and you had a phone call that was made by the deputy saying, hey, we're going to be releasing this black man, so it's time to get him. That phone call right there would be the overt act toward the completion of the conspiracy, and that would be enough. Whether or not they even caught the individual that they wanted to terrorize would not be a question. We already have a conspiracy because there's a legal agreement and the phone call was made to try to fulfill it, and that would be the overt act. So let me give you an example of a violation. Let's say that you're doing foot patrol in an area in a city, metropolitan city, and you have some people that are homeless who are camping in the park. And you and your partner basically get together and you make them pack all their stuff up and you have them move. You write the report that indicates that you move the homeless from the area. Now, the problem is because you direct your attention toward a status of certain people, you may have violated their rights. Don't concentrate on status. Basically say, homeless, I don't know what you're referring to, but we're enforcing a city ordinance which prohibits overnight camping and storing of personal materials on public lands. In other words, we're not focusing on the homeless. Anyone who goes into the park will also be asked to leave, and that's what you need to concentrate on. There's a case called Toby versus the city of Santa Ana where this came up, and it dealt with the ordinance regarding camping and storing of personal property overnight on public lands. Side note, officers who are standing around watching other officers violate people's rights immediately come under Section 242 of the U.S. Code. Title 18, Section 242 of the U.S. Code states that whomever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any inhabitant of any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such inhabitant being an alien or by reason of his color, race, than are prescribed for punishment of citizens shall be fined more than $1,000 or in prison not more than 1 year or both. If death occurs as a result of this action, then it becomes a felony. So the elements are acting under color of authority, and that to me means that you're pulling your badge out saying I'm a police officer, with specific intent to deprive any inhabitant of any constitutional or federal right. I'm not sure that you're going to be able to view a short video of civil rights violations, but I'll just give you some examples. One of the scenes in that video has some officers who are partying at a bar and they get really, really drunk. And they get in a car and they shouldn't even be driving. They're drunk driving. And they see a vehicle who they almost hit this vehicle, and the driver, honks at them, and they get very bravado and pull the car over, hanging out of their vehicle with their badges out, and they pull the car over and they jack the citizen up. And the citizen basically says, you better leave me alone. I'm going to call the police. And they say, well, we are the police, and they make a false arrest. And the end result is you see one of the rookies in the captain's office, and basically the captain's saying, you're going to get a suspension, but you have to worry about this guy suing you and also getting prosecuted for making an arrest without probable cause and also using your authority to stop him and causing a seizure under the Fourth Amendment. So that's kind of an example of how this could play out. Another example in that video that's really interesting is that there's a shooting at a bar, someone's dead, the cops come in, the bartender's there, the cops ask the bartender, hey, did you see anything? And he says, I didn't see anything. I was in the back. And they said, look, you better tell us something or we're going to take you downtown. Now, how many times have you seen that on, a movie? We're going to take you downtown. Well, really, unless you arrest somebody, you can't move them. So these cops grab this bartender, take him from his workstation, drag him downtown, and after 2 or 3 hours, they let him go. But the bottom line is in that situation, that was an illegal arrest, and it was a violation of his rights under color of authority. My intent is that if you are able to get to an online copy of the civil rights violation, you'll see a homework assignment. It may or may not be there. If it is, you need to do it for points. But what I want you to do is look at each of the situations and then list down what violation it is. Is it 241 or 242 and why you think it is? The next topic is qualified immunity. Now here's what's going on. Officers have to react to the information they get many times secondhand. And so the law has said, we have to protect officers. They go into situations where a shooting's been reported and you get a vague description and you have someone who's coming at you. You have to have the ability to take action with the information you have at hand. That's called 20/20 hindsight. I'm sure you've probably heard of that before, Monday morning quarterbacking. So officers are held accountable to the information they had at hand when they're going to use force or make an arrest or what have you. Now, there's 3 types of qualified immunity. The first is scope of employment. When you are about to do or are doing something that's consistent with your training and departmental policy. In other words, your department says you're going to handle something a certain way. You're going to evict people, or you're going to make arrests, or you're not going to allow someone to hold a rally without a permit. That is a departmental or a city requirement. Now, it might be in violation of the First Amendment, but you cannot personally be held responsible. The city might be sued, the department might be sued. Next is good faith. So the first is scope of employment, second is good faith. Reasonable belief that what you did was the best choice for you at the time. As long as you pursue the best choice based upon your training experience without malice. In other words, as long as you aren't lazy, as long as you are not making a decision based upon the fact that you're being stubborn, or you don't like the way someone is dressed, or you don't like the way someone speaks back to you, that you're making a choice that would be a choice that a reasonable officer would make in the same situation, you're okay. The third qualified immunity area is what we call discretionary. The law or rule is discretionary in nature. No mention of the word shall, and the law is not clearly understood. In other words, the penal code says that an officer may make an arrest. It does not say that it shall make an arrest, except in certain instances in domestic violence in a couple of areas, but those are far and few between. If you have a situation now where a person makes a citizen arrest and you do not process the arrest. You don't believe that it's a legal arrest or what have you. And that person comes back and kills the original complainant. You would have qualified immunity as long as you didn't do anything malicious again, that what you did again was there's discretion involved, and you also probably use good faith in something like that. Most of the times police officers get sued for bad decision making instead of being prosecuted. 5 things that get cops sued are use of force, escalation of force, deadly force, sexual harassment, pursuits, and this is a big one because officers don't know when to stop pursuing someone, and custody, mostly custody deaths where they're not paying attention to the person who's in their custody. Now, when we get back to when we start to talk about color of law, I want to make sure that it implies, or that you understand that that implies, an exercise of official authority under local or federal law. The officer's got to have the specific intent to deprive the victim of constitutional federal legal rights. An example could be excessive force resulting in a traumatic injury. A good example could be the Rodney King case. Now, everybody has their own spin on when you move in to arrest a suspect, but having taught defensive tactics for over 25 years, I can tell you right now that police officers, it's expected that you're going to get hit. You might get kicked, but that's part of the job. You look at a situation and you make a judgment call based upon what the percentages are of injury you and the suspect. Now, my training, the way that I train is that the least amount of time where there's a conflict between the officer and the suspect equals the least amount of injury to both the suspect and the officer. So the training that I do is mostly rat pack the person and pin them down and handcuff them using sheer force and weight. In the Rodney King case, you had officers who took turns beating Rodney King with police batons and never actually moved in to make the handcuffing. So, the issues that I see there is most of the agencies, at least in the Bay Area I train with, Richmond Police, Berkeley Police, Oakland Police, San Pablo Police, even the campus police at Contra Costa College District where we work, they wouldn't wait that long. They would strike the suspect, stun him, move in. Everybody takes an arm or a leg and handcuff them. They wouldn't prolong that beating process. And that's where we get into problems, because in a court of law later on, you had experts who testified that was not standard procedure, standard operating procedure for most departments, including LAPD. End result, Sergeant Kuhn and company and Officer Powell, go to prison based upon Section 241 and 242 of the USC Title 18. That's a perfect example of a case where this law was used against officers. Another violation that comes to mind was in about 1981. There was a case in El Cerrito PD where 2 officers are making a contact with a homeless man, and one of the officers puts the homeless man in his patrol car, drives him out to the marina, and forces him, under threat of being struck with a police flashlight, to walk out into the water up to his waist into the bay. And the second officer sees it. He was an ex-Berkeley officer that I knew of. I'm not going to give up any names here, but the end result is he reports it. The first officer gets prosecuted and does some time in jail. Both officers get fired. And that's a terrible example to use, unfortunately, but they took the person in violation of Fourth Amendment and then put him in danger by putting him in the water. Could have been a drunk, could have died as a result. And the end result is those guys weren't acting like cops, they were acting like crooks, almost a kidnap. The next topic is liability issues of intent. There are 3 levels of intent or action perpetrated under color of law. The first is intentional acts. Intentional acts usually fall under Title 18 USC Section 241 and 242, or Title 42 USC Section 1983. That section allows you to sue officers individually or departments under tort law. Tort law deals with civil law. So the difference between criminal law and civil law, in criminal law, you're going to have a situation where officers can be fined or placed in jail or put to death. In civil law, there's either sanctions put against the department or it's just strictly a money matter. They have to pay you money for damages. In a situation where there are intentional acts, officers lose their qualified immunity status. That means they may be paying for their own defense costs and damages, and they also may be terminated. The second level of intent is negligence. If you fail to demonstrate appropriate safeguards and/or behavior warranted under the attendant circumstances, it might not be a violation of 241 or 242. It might not be a violation of Title 14, 1983. There may not be a loss of qualified immunity. There will be definitely probability of state tort liability where you're going to get the heck suit out of you. The employer will most likely pay for defense costs and damages and discipline in most cases and potential termination if it was really egregious behavior. In other words, it was outrageous behavior. I'll give you some examples of that. I had an officer that I was supervising at one time that was just a terrible driver. The officer had been in 2 or 3 accidents. We sent him to CHP Academy to get trained in driving, and they actually sent him back to us and said that he was untrainable. At that point, we probably should have fired him and just dealt with it, but we let him continue to drive a patrol car, and result is he gets in a hot chase. He is driving like a madman on a main thoroughfare, and he gets in an accident where he actually slams a citizen's hips between the right rear portion of the police car and a telephone pole, and it crushes the guy's hips. Now, this guy gets back and he sues the heck out of us for negligence. The officer for negligence, the police department for negligence, because the officer had a track record and we were really in trouble. Now, we had to defend him because he was doing his job, but he was not doing it in a safe way. He was violating the speed limit. He was driving up on the sidewalk. Come on, that's crazy stuff, right? Now, as a result, we did get rid of the officer. But this was a terrible situation. This is a great example of negligence. A second example of negligence, it will be another Berkeley PD case. Berkeley PD had just moved to carrying Glock semi-automatic 9mm pistols. They had a 3 to 5 pound trigger pull, which is pretty light, and one of our officers got in a foot chase with a drug dealer. Drug dealer was armed, but that really didn't have anything to do with this. The officer was running with his finger in the trigger guard. That is something that we train in the academy not to do. We train in the police department. We try to drill this into your head to keep your finger outside the trigger guard. The suspect turns around to give up. Officer trips on a curb. Gun goes off accidentally and hits the suspect in the stomach. End result is that the city is liable and pays a whole bunch of money. And we had to go back in the training records. The officer actually said that his police academy never trained him to keep his finger out of the trigger guard. So that suit was against not only the Berkeley Police Department, but under vicarious liability, the academy that trained him also had to step up, and I don't remember what academy that was, but that would mean they would have to come up and they would be subject to state tort liability in addition. The next area that I want to talk about with immunity and intent is non-volitional acts, and that these are acts that are not consciously performed, a reaction or response to a non-controllable body function. So let me give you one. An officer in Inglewood, California, makes an arrest on a juvenile. It's a black juvenile at a gas station. You probably saw this on TV. And the officer is walking this handcuffed juvenile, and as they walk past the pump area, you see the officer grab him by his hair and slam him face first into the trunk of a car. End result, officer gets terminated by his police department from the videotape that the news crew had there. And he's saying, hey, I'm innocent. The kid grabbed me by the genitals, and it was a reaction. Lucky for that officer, the video camera from the actual gas station shows the suspect grabbing his genitals. And again, here's what the rule is. Non-volitional means you don't have any control over it. Somebody is gouging you in the eye, and you take your flashlight and you hit them in the head. Now, your department says you can't strike in the head with the flashlight. And so therefore, you might be liable, right? Well, guess what? If you're put in extreme pain, if you think you're in life-threatening situations, you react to it. And in this case, I think it was more or less a situation where it was a white officer, it was a black suspect, and the media just fueled that fire. But in that case, There's no Title 18 violation. There's no Title 42 violation. There's no loss of qualified immunity. And there's unlikely successful state tort liability. The employee is going to be responsible for paying the cost for court and any damages that come up, and very unlikely that there's going to be any disciplinary action in a case like that, because again, you're reacting. Okay, well that's it for this first lecture, part 1 on LD 15 laws of arrest. And I need to make sure you're reading the book. Make sure that you look at the discussion and homework assignments and keep up with your exams, as they're all related to these lectures.